Beg your pardon, my lord. Because for the judgment of this honorable court, my lord, the life of the petitioner has been stopped, my lord. Because his life has already been stopped, my lord. Because the lower court dismissed the divorce order, my lord. My lord.
Wait, please. And this is the
It may be listed.
Read to please, madam.
Parties are present.
Yes, Father.
We'll take up. Wait.
Item 16, your lordship.
Their parties are here. They're here.
Parties.
Look, sir, the 3 laws. Spending and finally laws.
What you want?
So to be listed.
List it all. Pick up.
Lordship, to be listed, being husband.
Give.
And after his time permission from the least bail item 55. That item will be taken up before, may kindly be taken up before IG for the reason. The decree of grant of restitution of conjugal right is challenged in the appeal. Now, a case has been levied by the husband in which notice has been issued to the wife appellant. And the
So after the personal appearance matters, we'll call personal appearance. We'll call that also.
Item 3.
Kindly use the mic. Your cases are weak, weakly argued, weak submitted.
Sir, request on your friend. Instead of interrupting the phone, you inform any of your friends.
Yes.
Page means.
Up to 10 we are not. Next.
Item 18, my lord. After recess, my lord, I pray, my lord.
Go beyond 12. Start with 13. 13 to 23.
My lord, item 18, my lord.
Yes.
I pray, my lord. After recess, my lord. I have some problem.
Afterward, you request any of your friend.
Yes, my.
Next.
Item 27. I am for the respondent. Hearing for next week and taken consent of the other side.
So you are for the respondent. Your name, sir?
G. Mohanty.
G. Mohanty. Sir, 27 when to be posted? August, 20th August.
Lordship, in this case, I am for the petitioner 27.
Appellate, you are for.
Yes, Lordship.
27, on consent of the London Council for the appearing parties, based on 20th of August.
Lovely.
Then item 29.
Item 29
to 36.
34.
Yes.
I pray 7 days time to obtain instruction from the appellants.
Yes, other side inform.
Yes, I have.
Other side now.
Yes, sir.
1 week.
34 shorter.
34, same order. In this term, 19th of August.
What's the paper shorter date, my lord?
Sir, actually, we are ready to take up it today. So when there is some eventuality, so please be patient. It can be 12th of August. We are already in the last weekend. Last but 1 week. Next week only 4 working days of July. Yes, sir.
Item 37 to 40.
37 to 40.
Item
29. All matters have to be called up at 2 p.m. All personal appearance matter will start at 2 p.m. If it otherwise doesn't reach, suppose no one is present before it reaches before 1 p.m. Then also it will be taken up at 2.
And since the child was called, if your lordship,
You can take it up.
since the child has been called, and if your lordship wants a personal interaction, that is why
Only in chambers at 12:45.
At 12.
12:45.
Chambers.
Oblate. They'll be there.
Yes.
41 to 43.
41 to 45.
45.
Your contract coming.
21%.
Sir, you are mentioning or you are
No. Item 1.
Item 1. Yes,
Item 1.
Item 1.
Item 1, the respondent husband is present here, my lord.
Husband is present here.
Yes.
Of Learned Counsel appearing for.
Item 3.
will take care day after tomorrow.
Day after tomorrow.
Yes.
Yeah.
Mr. P. Misra.
Next week we'll have.
No, day after tomorrow it will be.
Day after tomorrow on request. Yes, sir.
4 and 5.
4.
Four introduction. Both are airport. That they write. That's right. Second case,
Merit free ownership. Merit free ownership.
yes.
Before taking up this matter, I would seek to bring to your lordship kind notice that item number 42 also stand on the same footing. It was on last Thursday 42, and liberty was given to me by your lordship Miller to make a mention when this matter will be called. That is related to
as in 42, or you want extra hearing?
6 with 42.
Together with.
6 may be taken.
Can be taken together.
Together, Miller, because it is related to admission.
Again, you want to argue?
Miller, admission into Miller.
We have agreed. When we court agrees, further argument should not be addressed.
Oh, Miller. Sorry, I'm extremely sorry, Miller. Miller, this matter relates to Miller. AICT granted approval in respect of technical institution, which is existing technical institution, Miller. And the
Sir, you are at
judge,
42.
I am arguing in first matter,
This is
6.
a fresh matter. Notice to be issued.
Miller, this one, your lordship may kind- your lordship-
Already filed.
Already filed, Miller.
Yes, I counter your lordship. Your lordship has
7 count. 6 is counter. 6 is counter is there.
Yes, Miller.
already 42 also counted.
Everything is ready, Miller.
What is the grievance?
Grievance short.
3 sentences.
In gist, Miller, AICT, that is the central authority which has been established in the Central Act, has granted approval in respect of my institution, that is extension of approval, Miller.
1 second.
Miller.
Approval is granted on which date?
That is in respect of the intakes, Miller. Existing intake, Miller.
Granted on?
Granted on 9/4/2025 under Annexure 2.
This is intake approval.
That is intake, increase intake, Miller.
9/4?
9/4/2024. Under Annexure 2, document is there under Annexure 2.
Approval for intake capacity is?
Intake capacity is 60 in integrated engineering and technology, 60 seats, Miller. And 66 in engineering and technology, that is biotech.
That is 126.
Total 120, Miller.
120.
140, Miller. Miller, that is the disputed extent, Miller. So far, other approval is concerned, they are not disputing, Miller.
Which is not in dispute.
Dispute is not there. That is in respect of 1,000 index, Miller. It is existing and it is autonomous. It is a very elite institution of the state, Miller.
All right, after approval,
Yes, Miller.
what is the problem now?
Miller, problem is that the Joint Entrance Examination Committee, which holding the JE, Miller, that is the entrance committee, Miller. And through the entrance committee, all admission is to be made through the Odisha JE. That is the entrance, Miller. As per the state act, there is a committee. It is called Odisha JE. It is the OP number 2. They have already appeared and filed the counter.
But you straight away address us on the problem.
Miller, problem is that they are not including my increase intake, what has been granted approval by the AICT into the ongoing counseling process. Then another problem is the BPUT, it is the affiliating authority.
So what is the rule on the JE,
Miller.
including your seats?
Miller,
The extent rules.
the rule is,
Which are the rules? Kindly show us.
Miller, your lordship may kindly come to annexure, that is annexure,
That is the rule.
that is the act, Miller, that is the law.
Whatever.
That is the law, Miller.
Correct.
Your lordship may kindly appreciate for the law
Kindly
question.
not listening, sir.
Miller.
You have to listen the question. No question, then you can ask me. No difficulty. I don't mind that you asking me also.
Miller, sorry, Miller.
Sir, you have not been allowed to your JE, your grievances. JE
Miller.
is not reflecting your number of vacant seats in the counseling.
Yes,
Am I
yes,
correct?
Yes, Miller.
So what is the rule or law or the act on that?
Miller, your lordship
JE
may
to reflect your number
your
of
lordship
seats.
may kindly come to 60, Miller, 64.
Answer that.
60. As per the law, that is 2007 Act, Miller, provision 3 is very clear. Section 3 is very clear. Section 3, Miller?
Which page, section 3?
Miller, that is your lordship may kindly turn to 77, page 77 of my brief, Miller. 77.
Fee Fixation Act.
Yes, Miller. 46 I am reading out. 76, Miller.
76.
I am reading out 76. That is the
What is
provision.
page, section, what is that? 76.
76 page, Miller.
Page.
Section 3,
Section 3.
Miller.
In the Principal Act for Section 3, the
Miller.
following section shall be substituted, namely,
Millers. 76. Have your lordship got it? Miller, should I read out,
Yes,
Miller?
I'm just reading. Wait 1 second.
Give us a moment.
Institutions, all seats. Private and professional educational institutions, government institutions, sponsored institutions. What is sponsored institution? All seats, including lateral entry fees, shall be made through entrance test, provided by the government, approved by the government, followed by central council was approved as the country.
This one is there for it. They don't dispute one. They have to go. It has to be through the entrance only.
Okay. This counseling for admission. Vacancy on the position. Yeah, you are reading 3:1 now.
Miller 3, 1 and 2, these
Two
are
also.
relevant. Yes, Miller. These are the way in which manner JE will take the admission through entrance process, Miller. That is the way, Miller.
Yours is a private institution or sponsored institution?
I am private institution, Miller.
Private.
All seats, Miller. That is the language subject to the provision of this act. Admission students in all private professional education institution. I am a private self-finance institution before Lordship Miller. Then JE, it is the onus of the JE under this statute, Miller, to take admission, Miller.
So last seat is defined in this statute.
Yes, Miller. Seat means.
Kindly just look at 3 to 5th line.
Yes, Miller. Miller, your Lordship is referring. Sorry, Miller. Your Lordship is referring to the definition
I
clause.
think you have turned the page. 76. We were at 76.
Yes, Miller.
I
Oblige.
hope you are with us also.
Right.
3.2. The modalities shall be decided by the government
Yes, Miller.
from time to time for filling up of the vacant seats,
Miller.
taking candidates
Miller.
from entrance tests approved by the government on
Miller,
merit
Miller.
basis of all the technical and professional
Miller.
institutes under the supervision of the OJE
Miller.
EET committee.
Miller. Miller, it transfer.
So your seats say, for example, we are 1,000, but you want admission to 1,200. It's an example. I'm not
Yes, Miller.
arithmetic. I'm not.
Miller.
So how does one arrive at that whether it will be 1,000 or 1,200?
Miller,
So is it defined?
yes, Miller.
What are the seats?
Yes, your Lordship may kindly appreciate my submission, Miller.
No, sir.
AICT has.
Sir, your submission, correct, sir.
Yes,
Please,
sir.
please be patient. Which act defines this part?
Miller,
Is there any definition or there is a vacuum? It is
there is a definition. Miller. Seats means seats approved by the AICT.
Please kindly, sir, kindly
Miller.
show that.
Miller. Your Lordship may kindly come to the definition clause, Miller. Approved intake. Your Lordship may kindly come to 65.
65.
Yeah, the starting of the
Base 65. This is the dictionary clause of the
Miller. Miller, I'm just reading out clause B. Section 1, clause B. Approved intake.
Sir,
Means-
that should be not 1B.
2B.
2B.
Sorry, 2.
So,
Miller, 2. Approved intake means and implies the total number of seats sanctioned by the competent authority, statutory authority for admitting students in course of study in professional educational institutions.
Sir, please now go to competent authority.
Miller, then your Lordship may kindly come to competent authority. That is, your Lordship may kindly see. That is your Lordship may kindly come to professional educational institution. Your Lordship may kindly come to.
Competent authority. Sir.
Yes, Miller. I'm just coming to that point.
Not in this.
66.
66?
You.
Yes, professional institution. That is professional course. Another definition is
Competent
there.
authority, sir. Competent authority, which is referred in the dictionary clause
Miller.
2B.
So to be that is
Competent statutory authority. They use the term competent statutory authority.
Miller.
Number of seats sanctioned by the competent statutory authority.
Miller.
At what point?
Miller.
So does this act at page 30?
Miller.
So does it anywhere refer to any seat?
Miller.
C80 because
Miller seat means seat approval.
because The act which you saw at page 63
Miller.
talks about seat.
Miller.
Apex court has given.
That is approval, granting of approval. Then power of the AICT to issue regulation. Then the next page starting from the regulation. That is the way.
34 you are saying.
Miller, I am saying page 34.
Page
34. Power to make regulation. Should I read out, Miller?
No, it has power to make regulation.
Then your Lordship may kindly come to the relevant regulation of the AICT, the next page starting from 36. That is the way, manner in which the AICT will grant herewise approval or extension of approval to the institution pursuant to this regulation. That is the relevant portion of the regulation starting from 36, Miller. Your Lordship may kindly appreciate 36.
We are seeing
Approval process handbook, that is of the year 2027, Miller.
This one is that is the
Miller. Then your Lordship may kindly turn to the very relevant page. Your Lordship, the approval is seats definition is also there. I will come to that, Miller. 45, your Lordship may kindly come to.
45.
Chapter 22.
Page 45.
Chapter 22 of that approval. Page 45, that is my running page, Miller. I am just reading out. Chapter 2, grant of extension of approval for existing institution. I am an existing institution. My institution is since 2007, Miller.
Got the point.
Miller. Then grant of extension of UA. Your Lordship may kindly come to next.
2 is your case. Increase in intake.
Increase in intake and additional course, Miller. That is my case. Then your Lordship.
One second. Approval is in respect of seats. Intake capacity.
Yes, Miller.
And in respect of discipline also.
Yes, Miller.
Both.
Both discipline, course, program, there are separate definition of the AICT. I have already there, Miller. Your Lordship may kindly turn to the next relevant section is page is 46, Miller, of the AICT approval. I am concerned to this one, Miller. The another institution concerned to another page is there. I will confront it, your Lordship, for appreciation. 46, your Lordship may kindly come. Class 2.10, Miller. Should I read out, Miller?
2.10. Just 1 second. In respect of integrated dual degree courses,
2.10
shall be applicable. As
Miller, second, vital is the clutch eyes. Next page, 47. That is very relevant, Miller.
5 years.
5 years. My degree is, my course is that integrated course. I am just my grievance before Lordship for integrated. 5 years integrated degree in engineering and technology leading to master technology MTech nomenclature shall be as per the major disciplines of the engineering annexure 2.
That because you are not in challenge to their grant.
Miller?
You are challenging to the action of the JEE
and BPUT. Miller, the law.
So one is their power to grant you. They have granted.
Yes, Miller.
So they accept that also. I don't think there is a dispute.
But they are not allowing me.
But we have understood the case now.
Then your Lordship can come to the law. What is the law? Law decided by Jai Gokul case. Your Lordship can appreciate for a moment.
Yes.
That law is said they cannot stand against the law, Miller, which has been decided by the apex court as well as this honorable court.
Which paragraph?
Your Lordship may kindly turn to
which page, which paragraph, which decision?
Your Lordship may kindly turn to page 27. Sorry, page 44. Very inconvenient. Page 44, your Lordship may kindly turn to page 44. I will Lordship got page 44. Page 44 of my compilation of judgment, Miller. Just I have provided. 44. Para 27.
So, please, sir, because it is all smudged.
44.
44. 44. Para 27 of the judgment.
This doesn't look. This is Jai Gokul.
That is Jai Gokul, Miller. That is AR 2000. Miller, I have given the replica of that judgment. 27, I am just reading out for your Lordship kind appreciation. The so-called policy of the state as mentioned in the counter refusing approval. In such a
Mr. Das, where you are reading?
Only for
Where you are reading, I was not getting. You have left
27. Page 44.
Policy.
Miller.
This we will go after we know why they are not doing it.
Miller, then your Lordship may turn to.
Kindly, Mr. Das, allow us to also interact with them.
Now
You have made out a good case.
Miller,
So let them
then I am obliged, Miller.
and let us
I am obliged
see
with
what
that.
they say.
Oh.
Yes, brother. Who is the approving authority? Who is the test conducting authority?
Miller, J is conducting examination. We are filing our counter, my lord, today in course itself, in 42.
You sought copies also.
We have sought copies to all.
All right. What is the reason why you are not allowing?
My lord, for these private institutions are coming under the BPUT. BPUT has established on 2002 and BPUT statute, first statute has come on 2006. In the BPUT Act statute, I have stated in page 4, my lord, page 5.4, affiliation of new courses, continuation of affiliation of existing courses in an existing institution, college in subsequent years or in a new college shall be subject to scrutiny by the university. My lord, here the university is
Sir, you are not
BPUT.
referring to para 4 or para 9. You are not referring to any statute, any rule, anything.
Section 18.
My lord, BPUT statute 2006, my lord, in para 10, my lord. Page 4.
Approval of basic affiliation to goods.
In next page, my lord, in page 5.
Scrutiny by the.
Scrutiny by the university. Here the university is BPUT.
But whether there is
It is
a.
not common record. Called.
This affiliation shall be ordinarily accorded on a yearly basis.
This is by the J, this is by the university.
So you mean to say there is no affiliation?
No, they have not get any affiliation for the new courses, the intake they have claiming for.
Okay.
They have only taken approval from the AICT for
1 second. You mean to say for your processing the claim, affiliation is a precondition.
affiliation is the precondition because my lord, they will not get any certificate. The students will not get any in future. They,
Understood. If there is no affiliation, what will happen? We know that.
my lord,
That Venkateshwaralu University versus so and so and so.
Yes, sir.
Who is the affiliating authority?
Deputy.
After they got the approval from the AICT, did they send any request for grant of affiliation?
Yes, Lord. There is a physical verification as per the Lord.
When 1 second. When they sent that request for approval affiliation,
Lord, kindly similar the page, page 59, Annexure 3.
page 59.
Yes, of the rate application.
No, we are asking you the date.
Yes, date
When
is
did they apply?
1/5/2025.
They got 9/4/2024.
Yes.
On 1/5, they applied for affiliation.
Yes, ma'am.
What did you do with that?
Lord, thereafter, Lord, we formed the committee. And committee has verified.
When did you form the committee?
Lord, 31/5/2025. The next place.
1 month you took.
Yes, 25.
25.
Yes.
That means more than 1 year.
No, Lord. 1/5/2025, Lord. They have requested for.
They applied for affiliation
Yes.
1/5/2005. Is it correct, brother? Just to tell us whether that date is correct. When did you apply for affiliation?
Millard, we have applied for affiliation. That is under last annexure page
We do
9.
not know. We are asking the date to
The
you.
date is 12 June, Millard. That was the
12 June of 2026.
25 Millard. My annexure is there, Millard. 70.
12/5, you are saying 12/5, he says 1/5.
12/6 Millard.
12/6/25.
6 Millard.
But he is saying 1/5/2025.
Millard,
you
1/5
applied.
maybe factually incorrect, my lord and friend Millard.
Anyway,
But
No, it's not a. You have annexed that annexure.
that is not the affiliation. You are in.
No, new post sanction
you
to our
cannot be
institute
right
and we
for
request for.
simple reason.
Millard.
Committee itself is constituted on 31/5. Therefore, your application has to proceed.
Yes, that is what the annexure.
You are right. You are right. He cannot be right. Logically, he cannot be right. Yes.
So the next page, your lordship, see 31/5, we have formed the committee.
Yes.
And committee has verified all the as per the norms of the AICC.
When it happened?
And 1/7/2025.
Yeah, that is inspection.
Report. No joint certificate, kindly see page 61.
No, you are not answering the question. You are avoiding the question.
No, I am not avoiding.
When did the committee visited the institution?
The date of visit, one. Must have been in the counter. I want
your counter. You look into and tell us. You have also counter. Your counter only.
Your counter.
So you have shared this.
No, please. I have to see blood date. Yes, you take it.
But everything appears to be very delayed, like laid over, sleeping, tardy. Because the fate of the students is involved.
Millard, 9 June 2025.
9/6/25.
Yes.
All right. In report, what is stated?
This blood stated that no recommended to the integrated computer science engineer with intake of 66, not recommend for integrated biotech engineering or intake 66. Blood were not
You are not given affiliation.
Because
it was communicated to, as per the report.
Yes.
After that report, how process takes place? Report committee gives the report.
Yes, that has been communicated to the principal of the.
Now, did you share the committee report with them?
No, Lord, I have intimated the order.
We are asking the question. Please do not avoid.
No, Lord.
Did you share copy of the report with the institution?
That the instructions, the news and the details.
That is how they will, because that's what
we do not know.
Ramjan Khan says, na? 91 Supreme Court.
Correct, Lord, but that part, Lord, instruction I don't have at present, Lord. But Lord, we have already informed that what is the basis of not giving the recognition affiliation for this intake, but additional intake.
All right.
But the report, admittedly, the report I have to take into whether I communicated to him or not, that part instruction.
So what is the last date for admission? What is the last date for admission process?
Millard, last date is 1st August, Millard.
1st August.
1st August.
Right.
But as per the Supreme Court guideline, Parasbarnath case, the last date for admission starting of session is 15th August.
15th August.
Everything will be
follows the cross counseling. Unless you cross the hurdle of the process of counseling. So first, let us concentrate on counseling part because you are yet to start counseling.
Millard, second part, your lordship appreciated in the act, Millard.
No, that's not the affiliation.
The second part, my lord, I have read out, and my lord, Honorable Justice M.S.Sahoo has made a question. 3-2.
You see, this is the question on part of the bench.
Millard.
Anyway, now they say affiliation is a precondition.
Millard.
Admittedly, you don't have affiliation. Maybe they are wrong in not giving affiliation, but that you are not.
It is not correct, Millard. They are not correct. I will come to that point, Millard.
So have they granted affiliation?
Millard,
So that's kindly follow the question. That is how I have to ask so many things.
Millard.
Is it your case that they have granted you affiliation?
Millard, not. That is my prayer.
Then when my lord asked you should have said not correct. You should have said yes. They have not granted you affiliation is correct.
Millard.
Have you challenged non-grant of affiliation? That was the second question fell from my lord.
These two questions will arise.
Millard.
Whether affiliation is a sine qua non,
Millard.
a precondition
Millard.
for the grant of approval.
Millard. Millard.
That is the first question.
Millard.
If answer is no, then we need not travel to them at all. We need not traverse that contention.
Millard.
If affiliation is a precondition,
Millard.
then you have to show to us
Millard.
affiliation has been accorded.
Millard. Millard, I understand, Millard. Your lordship may kindly appreciate the AICT approval. Affiliation is not a precondition for granting of AICT approval. AICT approval is a precondition for granting of affiliation, Millard. when AICT
For
granted
Vijay, sir.
Miller,
For
Miller, no Miller.
don't say no Millard for everything.
Miller.
The answer cannot be no Millard.
Miller.
It is absorbed. Perhaps we are interested.
Miller, no Miller. OJ counseling Miller, BPUT affiliation is not required Miller. That is clear Miller because we made the application for affiliation on 12 June Miller pursuant to the BPUT advertisement Miller. Whatever the date my learned friend is submitting that 31st May Miller, that is our intimation to the BPUT that we have got the AICT approval. It is intimation to you. Apart from that Miller, AICT itself in its approval accorded on 9th April Miller, they have intimated to the BPUT Miller. But the affiliation process started by the BPUT Miller in the month of June 2025 Miller. Month of June. Before that,
actually the difficulty is that maybe
before that,
Mr. Das,
they has started the council.
Mr. Das, please don't state the obvious.
Miller.
Maybe appearing to be interfering a lot, but actually it is not. Because we are trying to make out a case for
oblige Miller. I am also appreciating, but in post, what should be the facts I should support?
Kindly. Don't go on a that kind of a deliberation. You are saying that is it your case that affiliation is not required for counseling?
Yes, Miller.
That's the case.
That is the case, Miller.
That is agreed.
Affiliation is not required for the council. My prayer is Miller, AICT is BPUT OP number 4 may be directed for granting of approval in respect of that increased seat, Mr. That is my prayer before leadership. But when the JE starts its counseling process, Miller, they have not granted affiliation in respect of any institution, not my institution, any institution of the state.
No.
That is the practice.
Increase, sir.
Not any institution, Miller.
Then you would not have challenged their action or you would not have made the prayer also. The issue is when if you are jettisoning that approval from your whole system,
Miller.
that BPUT as far as counseling and admission is concerned, BPUT has no role to play.
Miller,
To that extent you are submitting now.
Miller, you will also kindly appreciate Annexure 6. Annexure 6 for a moment.
One second.
Annexure 6.
Kindly. In other institutions
Miller.
where affiliation is not granted,
Yes, Miller.
have you enlisted them for counseling?
If I have to take instruction in this matter, Miller, as per my instruction, OJ has instructed me that in para 6, so in deputy statute, very much.
Your friend is very specific. He says,
Miller,
what my lord?
We have
not completed the sentence itself. Your friend says, in respect of many institutions, if not all, there is no affiliation at all. Even then, you are favoring them with whatever process that is statutorily prescribed. Is it true or not?
I have to take instruction.
Why instruction? Call him and take. You have to see in educational matters. You have to keep your officers behind you. Otherwise, for every sentence, you will say, I have to consent. Then why lawyer is required?
Tomorrow, Miller.
Yeah, you call your, we'll pass which place he has to come from?
He'll come from Bhubaneswar, Miller.
Bhubaneswar, ask him to come.
Tomorrow.
It's the fate of the students.
Tomorrow, Miller. On 24th, the registration of second OJ will start. So I pray for tomorrow.
That is the reason, sir. How the court will deal in one day. You have not dealt with in 2-3 months. They come to court.
No, we have one request to you. In all educational matters, wherever authorities are appearing, wherever colleges are before the court, you have to keep persons who can advise you. Otherwise, 110 questions will arise, 110 adjournments we have to give. By that time, 105 students will commit suicide.
Sorry, Miller.
Therefore, you should keep your officer with everything in his pocket or in his hands to answer our questions. These are educational matters. We cannot play with the lives of children. It is not just the question of the institution. What is happening outside you have seen. Very sensitive mind children today have. Therefore, these things. You have to keep your law officer present before the court. Your next case, we will not hear. We have to consult and come back. That is not the object of advocacy. The advocacy of one of the tenets of advocacy is having marshalling of the facts. Any standard book on advocacy by Chandrasekhar Iyer. Marshalling of facts. What are the possible questions which the court is going to ask? Yes, these are the questions. How these questions are answered by the court, by the authorities. Provisional affiliation is granted to you.
Provision, Milord, they are granting provisional or affiliation year-wise. Milord, every year they are granting provisional affiliation, and the AICT is every year granting extension of approval, Milord.
Section says you have to answer without affiliation. For every such approval, affiliation is needed. Which is that section?
That is, Lord, Section 4 of the University Act. Lord, it is referring, Lord, which is the OJ counter, and you have a glance. Phase 5, it starts from phase 4. Paragraph 10.
Ask your officials to come here with all files. Okay? Then they cannot say we have to go back and bring.
Right? Statutes,
Everything. One set of your university statutes.
That is
okay. And whether you are conducting counseling in respect of institutions which have not been granted affiliation, that also you have to state.
So both you are referring to which para of?
Para 10 of the OJ counter. Phase 5. So start from phase 4.
We have some difficulty because we did not have. Right now we have received this also. It's matching. Para 10.
Para 10 last para. The universal grant application from the.
Just give us a moment. We'll get there.
Yes.
Now we can read it.
May I please? Yes, please. The universal grant application from time to time differ institution college imparting technical education the state as per the provision under subsection 2 of the 18 of the Act. Any college institution willing to prepare the student following the curriculum, syllabus, and regulation of the university for the examination and award of the degree diploma of the university either be a constituted college or a affiliated college. All institution colleges imparting education at degree level and above in engineering, pharmacy, architect, interdisciplinary materials area in computer science, management science, hotel management, biotechnology shall be eligible for course-wise and institution affiliation to the university. New institution colleges who intend to offer such course as
Section 3.
Yes.
All institutions will have the
affiliation before start of the program.
3 types of affiliation.
Right.
Institutional affiliation.
Right.
Discipline affiliation.
Right.
And program affiliation.
And 4 is affiliation for new course and
new course affiliation also.
Yes.
Whether that affiliation is granted in a wholesale way or for everything given piecemeal.
Lord, so far as this case, Lord, here's Lord, additional seats is required for affiliation, Lord.
Of new course affiliation with such a course subsequent subject to the botany building university. This session will be again recorded on a yearly basis. Course-wise basis. Course-wise basis. Just in part. It goes basis. This is a course-wise affiliation, which now we have to consider is.
Lord, here in this case, Lord, tomorrow I'll explain. In this case, Lord, the institution has not fulfilled the AICT criteria of the ratio of the teachers and professors to teach the student.
The teacher-taught ratio.
The ratio. That is the ratio decided by AICT. He is not fulfilling the ratio of the AICT. So therefore, my lord, he has conducted inquiry and given a report that this is the discrepancy you have. So therefore, he is not eligible to give the affiliation. And my lord, your lordship see the chapter 4 of the AICT. It is not enclosed by petition, my lord. Chapter 6.
While granting approval to the institution or course, as the case may be, what all the factors they look into?
They are AICT. I have already filed the AICT approval process book, Miller. Whatever they are stating in their counter measure, that is the student faculty ratio is not maintained, Miller. As per their calculation, Miller, AICT has already examined it, Miller. That is the lookout of the AICT, that the central body, Miller. They have granted.
Granting affiliation.
Miller.
What are the factors you will take into account?
Yes, that is what Lord I am giving. Lord.
Yeah.
The AICT approval that is missing in the rate application, not.
Miller, with apologies to a lordship.
Kindly give us some movements.
That is missing, Lord.
Both of you are on top of your brief, so at times we are also left behind. Because this usage is not part of record now. We have
That is not there. I mean, by mistake, Lord. It's not.
Last occasion, I have provided a copy to your lordship. Last occasion, I provided the copy of the refute.
Para?
6.1 formula. Page, internal page 55. That is in the technical institution of flow norms of faculty, requirement and cadre ratio in diploma, undergraduate, postgraduate level as prescribed annexure 5 of the approval process. And so their ratio has been given, Lord. That he has
Annexure 5 you have provided?
Yes, Lord, they are provided, but which page? No, that is the 5. Lord, the faculty, their professors shall be appointed, guideline given annexure 5, Lord, in the handbook.
That is the AICT handbook, Miller.
That has not been included.
No, you mean to say university need not look into?
Miller?
Teacher-taught ratio.
Miller.
Apex Court has said.
Miller.
Even affiliating body can look into.
Miller, that is the AICT lookout and AICT had examined. We are maintaining it, Miller.
No, at one time, while at the time of granting,
Miller.
you may maintain. Subsequently, if you drop those teachers,
Miller.
what should happen to the student?
Yes,
Therefore, university, if you want affiliation,
Miller.
if you do not want affiliation, they are not bothered.
Miller.
If you want affiliation from them, you are under their suzerainty.
Yes.
You are under control.
Miller.
You are under scrutiny of the university.
Miller.
One condition is
Miller.
for so many teachers, there should be so many, for so many students, there should be so many teachers.
Miller.
If that condition which AICT itself has prescribed,
Miller.
if you do not adhere to that,
Miller.
we do not grant approval, is affiliation is their stand.
Miller, since we have, with great respect, Miller, since we have satisfied that condition to the AICT, AICT
You
has,
need not, university need not ask that one.
Miller, AICT, university has asked, Miller, we have satisfied it, Miller. We
When
are
have you
not
satisfied?
lacuna, Miller.
No,
Miller,
they are saying they have sent the rejections.
Miller.
They have sent the application being rejected.
Miller.
Did you challenge that application?
Yes, Miller.
Which is
that is your lordship kindly turn to annexure 5. That is my prayer also.
So that's which read application?
Miller.
Both.
In
Challenged that also.
Both annexure 5.
No, Miller.
That
In
is
the
the
first
condition.
one,
That
in
is
the
the
first one, annexure 5 is the relevant.
No, where they have now pleadings are completed.
Miller.
That is 18294.
That is 19441.
Two pleadings complete.
Miller. Reading completed in both the cases, Miller. They have filed the counter, Miller. But your lordship may kindly come to page 61.
We did not receive actually, so that is how we're trying to get it from the registry. So that is how I was asking you. With us, actually, we are having 18294.
Miller.
So you refer to 18294.
Miller. Page 61. Your lordship may come to that 19441, page 61. ये जो ट्राइज एंड I will lordship got annexure 5. But let's see, we got the annexure 5.
Just give us a moment. Give us. In Annexure 5, they refer to AICTE APH. What is the full form of APH?
Approval process handbook, the annexure 1.
Handbook 2024, 226, 27, format 2.
Miller.
So they intimate you that after following that approval process handbook, they do not recommend. Even they go by the AICTE.
Miller. My case before
your contention that
Miller.
they once AICTE gives, it is the final say.
That is.
But they also rely on AICTE APH format 2.
Miller. That is the core question. Now your lordship has got it, Miller. But I am obliged to it. I will not receive it. The other questions have already been answered clarified by my learned friends and journalists.
What you say is,
Miller.
once AICTE grants approval,
Yes, Miller.
it takes care of teacher-taught ratio also.
Miller.
Only thereafter they grant the approval.
Yes, Miller.
Therefore, the university cannot re-examine that issue and say that you have not complied with that. Therefore,
yes,
we do not
Miller.
grant approval.
Law is well settled. That judgment is there, Miller.
What is that judgment?
Yes, Miller. Then your lordship, I am just reading out that point, Miller. My lord has made a question. Should I answer it, Miller?
The question is not that. When they are inspecting, they are applying AICTE APH format. So their intimation to you is that
Miller.
as per AICTE
Miller.
APH format 2,
Miller.
your criteria is not satisfied.
Miller. Miller.
So what is your answer to
Miller, my humble prayer before, humble contention before lordship in
that? Just give us a
pleading.
moment.
Miller.
One is approval by the AIC.
Miller.
We are going slow because I do not have
Miller.
about education law.
Miller.
Once we
Miller.
do one case,
Miller.
that's going to be
Miller. I am trying to my best of my ability to achieve scholarship. Miller.
approval by the AIC,
Miller.
affiliation with the university,
Miller.
and the NOC by the government.
No, NOC government is not there. Not there, Miller.
That is letter of the government. Government has authorized BPUT.
What the NOC?
For NOC, Milord, your lordship, see annexure.
Affiliation is different, your NOC is different.
Yes, that is what Milord, the government letter, your lordship, that is annexed in the Milord application. Kindly see space 62.
Next annexure, 62. I have already annexed, Miller.
Who are asking? Affiliation is different, NOC is different.
No, NOC for affiliate. NOC is not for no just article with regard to Milord, the intact Milord seats and all these things. Milord.
Intake and other things are over at the hands of the AIC.
No, Milord, the affiliation. Thereafter, the affiliation.
Just give us a move.
मैं चाहिए बोलो जगह
Which the government has a role.
That is a state university, not state university, the BPUT, and they are the technical authority. Milord, they are coming under the Milord, the department's skill development technical education department.
Because some experts say a university is not an extended department of the government. Unless the statute authorizes, government should not put its nose into the affairs of the university. Which section?
Lord, this is
Show what is the role of the government.
Lord, it is a technical institution, Lord. And technical institution, Lord, within coming with the hobby of this department, skill development, technical education department. And this department is not looking after the technical education of the state. So therefore, Lord, it is
Just to answer the question.
Yes.
What is the role assigned to the government under the scheme of this act
Yes.
or your university act? What is the role assigned to the government?
Doctor.
There is a category of decision, a
Yes.
short road of decision, saying that government cannot poke its nose into the affairs of the university unless the statute authorizes it.
Yes, ma'am.
Now you show, which otherwise one affiliation, one approval, and one mercy, one consent letter, one agreement.
Yes.
Endlessly you will be troubling the institution.
Approval process can be 2021 as per the
Yes.
that format one,
That format.
that refers to government NOC.
That
Because you are relying on 62 even to assist us.
yes.
Because we are trying to understand also.
Yes.
Yes, we can look at 62.
Page 62. Yes, Your Lordship.
In the one day also one.
Yes, Your Lordship. University issued.
Want to say that we have requested for clarification regarding issue of relating to the colleges other than pharmacy.
Yes.
Prior to the application. With respect to the facts and provision of law. The council has decided regarding grant of university by state and DPUC and the application by the DPUC. Yes, can be further. Grant of fellowship from the state government. This way the discussion now.
Yes.
The state government in this department as such has no
Mechanism of power.
Manpower to conduct the physical verification of the institute applying for NOC for the prescribed items as prescribed in. So this I was asking you. So is it prescribed in format 1?
Yes,
As prescribed in format 1 of the approval process handbook.
Yes.
21-22 of AICT. Hence, BPUT is hereby assigned with the physical verification in online, offline, hybrid mode basing upon the relevant documents submitted by the institute and submission of verification report to the government for scrutiny and issue of NOC in favor of the institution. So our query was, does government has any role as has been discussed in so many decisions?
Not.
And whether format 1 they are actually provides for government NOC which they have delegated. They have delegated to BPUT.
And their power to delegate.
Power to delegate it also.
But whether the government has that authority or not, that.
But whether it has authority to issue or not to issue approval, any role to play. Number two, if it has a role, can it assign it to some other person? Because the delegatus potestas delegare, which Supreme Court considered. Therefore, two things you have to show. First thing, government has a role. Who appears for the government? You appear for the government in this matter. What is your role under the statute? Which statute?
So can this Annexer 6, which is reading out at page 62.
Now, under which section it arises?
This has been specially in Form 1 and Form 2,
Which are
the
the
approval process of handbook.
what is the statutory status of handbook?
Handbook of AICT.
Who issues the handbook under which section?
Miller, that is AICT Act 23. The act is there under Annexure 1, Miller, starting from page 24.
Statutory posts as per.
Yes, that is
Statutory portion.
Miller.
Kindly refer to the annexure is referring which section?
23.
23, Miller.
23 in 19441.
Miller, that is page 34.
34.
Yes.
Section 23 of the AICT Act.
It gives power to
Make regulations
Rules and regulations we understand. But whether handbook is part of rules and regulations? Handbook is it's a compilation of rules and regulations only.
Yes, madam. For approval process.
For approval process.
Page 36. Satish Dekhantu. Over to function. This is the approval process.
36 starting from APH, Miller.
In approval process, what is the government's role?
Miller, government rules is nothing. That is my case, Miller. So let's me kindly appreciate. That is my case, Miller.
In fact, you have not raised any. So, but I'm trying to always ask.
Miller. The government role, Miller, so far annexure 2 is the relevant. You may kindly come to page 46, approval process handbook.
No, sir, that format 1 and format 2, have you annexed that?
Format 2 is not applicable to our case, Miller. That is my case.
Could be, sir.
Miller.
One is saying that it is applicable since page 62 refers to format 1 and format 2.
Page 47 refers to annexure 2.
So kindly look at page 38 again. 38 again.
Miller.
Last, serial number 15, formats and certificates.
188.
Page 188. You have got 38 page of your brief in 19441.
38, Miller. Yes, Miller, I have got it. Index, Miller.
Index.
Yes.
Go to serial number 15.
Yes, Miller.
Formats and certificates.
Miller.
Now, if you correlate with format mentioned in 62,
Miller.
Format 1 is state, format 2 is university.
Miller.
State has completely delegated the university
Miller.
that format 1 along with to be issued with format 2.
Miller.
So, format, the question fell from my lord is that whether these formats are part of the statute, but you are saying that they are.
Formats are part of
Miller.
approval process.
But so far my case is concerned, Miller, annexure 2 says that I have annexed it, Miller, that format is not applicable increase of course, Miller. That format is applicable for other purpose. You will kindly appreciate 48, Miller, again. I have not placed the 48. 40 is very important, relevant document. You will kindly come to 48, which is part of the approval process handbook. Annexure 2.
6.14.
Miller?
Approval process handbook 2024-2027.
27.
You are having copy.
Yes, Miller.
Look at that, which just now was placed. You have read that.
Miller.
Satpathy?
Yes.
Which paragraph you are showing?
6.14.
6.14, yes, sir.
That is not in the.
Yeah, with it,
So 6.148. That is a teacher taught ratio. What is that ratio? For how many students, how many teachers?
Blood the course blood D, kindly see blood surplus D.
D. Adjunct faculty.
Yes, ma'am. Design course service, adjunct faculty, industry expert, professor of practice can be utilized up to 20%. For planning courses, service, adjunct faculty, industry expert, professor, up to 30%. Then, Millard, in all program, institution may avail the service of adjunct faculty or professor practice with the rich industry experience up to 15% of the required faculty strength. However, number of professors shall be not less than 10%. Guideline issued by the UGC shall be followed strictly in appointment of professor of practice. On similar lines, a professor of practice institution may avail the service of industry expert having 5 years and 8 years in associate emerging, multiplying area as assistant professor of practice and associate professor of practice respectively.
So your case is that
they are not fulfilling
the taught ratio is
not fulfilled. Therefore, the student, the career of student in stakes. So therefore, the university is not allowing us giving the faculty.
Where is that report?
That report,
725 report.
That report, I don't have at present. I am only not giving the in my counter. Can you not get it by email and print it? Yes, tomorrow I can produce. This is all Kela by tomorrow. Email.
Oh, statutory scheme we have understood now.
It's similar.
How things happen, we have understood broadly.
But how email, does it take more time? Okay, tomorrow I can.
So, I mean, we are adjourning it to tomorrow.
Yes, I can-
But if you can place it today, maybe he will have difficulty to answer if you
No,
start.
that is in their
No,
presence. They are present, that has been
No, no, you
corrected
you
and
said
they
that.
are signed on the.
You said that. You said that.
No,
the
it is a
notice
practice,
query.
Lord. They are signed on
Correct,
the
correct. But
report.
for judicial scrutiny.
I can produce. Tomorrow I can produce, not a call for the.
But he says, you cannot take up that issue at all is his contention.
No, that is not usually in the all
The addition of the.
Millard, you Lordship, I have already provided. Millard, my learned friend was argued in one decision. It's a full-fledged decision, and he lost it. Millard, that is.
No, I have not lost it. That is what.
No, you are.
I'm just
I learned made a question.
Mr. Das, I think AICT is also with Mr. Satpathy. The very what he said in his own time. He's saying something like Mr. Satpathy's
54.
54.
So that's it. Lord, in similar cases, Lord, same issue was Lord before this honorable court. And
He says you have lost it.
No, I have not lost it. We have not lost. The conclusion made my request, my lord. The court has observed and further, my lord, the institution has been entered into by both the AICT and the university together and signed a report. So, my lord, that is not. I am assisting and helping.
Yeah, no, I am obliged for your assistance.
So therefore, what this ambiguity, my lord, this ambiguity.
Judgment list.
No, if all you are agreeable, as my brother
Miller
said, if you are all in agreement, that we will verify everything and come back.
Yes, ma'am.
Once again.
Millard.
With that understanding, we will adjourn this matter.
Yes, that is what I want to start it with.
And we will make some order saying what should be the nature of the structure of the order.
Millard, that is annexure. Already. That is page.
Yes. You file joint memo.
Without my academic concept.
No, you do not sign, sir. No, sign, sir, but prepare it.
No, that is there, Mr. That is there.
That is there. Mr. Satpathy, you are discriminating.
I have
other things you have requested the court and you agreed that there will be together verification by AICT, your authority, and
I have already filed the judgment.
That is
already filed in bunch of judgment.
No, that's the law.
It's a law.
Millard.
But now we have to adopt that.
In what I said, that is the order, Millard. What I said, that order is also included, Millard.
Should I read out, Millard? Page
Let us find it. We are not getting this one.
No, that is.
Judgment, so 83. Your Lordship may kindly come to page 83.
83?
Yes, Millard. That is starting of the judgment of this division bench of this honorable court. One before the last session, Millard. And 88 is the relevant portion.
88?
Yes, Millard. That is quoting para 27 of the Jaya Gokul case.
After referring to Gokul education?
Yes, Millard. Then, your Lordship, should I read out, Millard? Just after ending of that quoting, Millard, should I read out with your Lordship kind permission? The applicability of the aforesaid principle. Millard.
No, para 9 you may place. 87.
Millard.
But there is a direction itself to grant affiliation.
Yes, Millard.
After proper verification.
After verification.
If it is not fine in terms of the IACC guideline.
For that only you are saying that not your consent. Because unless we set aside that non-grant of appellation,
yes,
then how can you re-verify?
No, that
but this can be interim order.
That your Lordship. He is not accepting the report of the university.
So thus maybe you have to take a call. You do not press this. Go for interim verification,
yes,
and abide by it.
Yes.
Can you obtain that instruction by tomorrow?
Time period will fix so that.
But we have to keep the matter pending. Otherwise, we have to keep the matter pending. Now, just look into our draft version. It's not an order. If you want to agree and point out whether that can be done, then we go for that way.
Prior to that, may I place the judgment of this honorable court? That is a comprehensive judgment. That is there. Your Lordship, I appreciate just 2 paragraphs. Everything will be clear, Millard. Page 54. I'm just reading out. Based upon that Jaya Gogol, that is a very comprehensive judgment.
You are delaying the process because when something is coming in your favor, why you are delaying it?
Everything, that para 54, your lordship, should I read
Page that down.
page the 54, 54 of my judgment list, what your lordship has shown to me. The judgment, the
Correct, sir. What is that judgment? Jai Gokul.
No, that is our own High Court judgment.
It must be having a name.
Yes, Mira, that is in the case of Silicon Institute of Technology.
Justice Chief Justice Javeri Saab and Mahapatra.
Silicon Institute.
Yes, Miller. R.N. Biswal. That is page 46 starting. Silicon Institute. Justice R.N. Biswal.
Page numbers in our paper book which you have given to us.
Miller, 46.
Is there, 27 is there, 55 is there.
46. 46, Miller. Page 46.
Silicon, no. Please refer to the paragraph. We are not getting. Silicon.
It's paragraph 14.
14 of Silicon.
Yes, Miller. Should I read out, Miller? 14 your lordship got?
No, that does not appear to be the correct position of law.
Miller.
As my brother have correctly put say,
Miller.
the university is not sitting over in appeal over the AICTE.
Miller.
AICTE literature itself assigns a role to the university
Miller.
and a role to the government
Miller.
and a role maybe to the examination authority also.
Miller.
So a very sweeping statement,
Miller.
which prima facie we saw.
Miller.
We do not propose to, we are not that inclined to go by that version. Otherwise,
Miller.
if we agree with that, AICTE will be the final authority
Miller.
and will exclude affiliation,
Miller.
approval.
Miller.
That is not designed.
Miller, that is the
So that let us,
Yes, Miller.
you see, please don't spend time on this because
Tomorrow I will come with that.
three of you ably assisted. We have seen format 1, format 2, 16.4, everything we have seen.
Miller.
So we interrupted when Manor started dictating the order.
All right.
That was partly largely in your favor.
Miller.
Petitioner institution has approached this court with the following prayers. Please be seated. This is only a draft order. It's only a draft order for our notes.
Please appreciate that because when my lord started dictating, it was clearly said that it is for your conscience. Please be attentive.
Your inputs also.
Your inputs will be there, and if you agree with that, that will be the interim order.
Next paragraph. After service of notice, the respondent university is represented by the panel counsel, Sri so Sapati.
Sit down. No chair. Sorry.
And AICTE is represented by panel counsel, Sri so and so. Government is represented by AGA Mr. Mohanty. First. Learned next one sentence. The pleadings in the matter are also largely complete. Contesting respondents having filed their reply statement. Different objections to the but it counter. First. Next paragraph. The short question that arises for consideration in this case is whether once the AICTE accords approval under the provisions of the AICTE Act and the AICTE rules of regulations that are together called or put in a handbook of procedure, whether there is a role of government for granting approval, stroke NOC, whether university is bound to accord affiliation regardless of prescription in the said handbook. First one. Learned counsel appearing for the institution draws our attention to a coordinate bench decision in so and so to description.
040 of 2023, order dated 11/9/2023. That this will find with mark page 83 in the compilation.
To contend that,
The same lawyers are same actually.
to contend that the university or government cannot sit in appeal over the AICTE, and therefore, once AICTE accords approval, a single bench, you can say not coordinated.
In Silicon Institute,
Versus, so we'll put the black there. Just
I'll put it, sir.
It's here. Incidentally, the same set of lawyers have assisted the learned single judge in that decision. First. Next paragraph. Learned panel advocates appearing for the AICTE. That one gets to be. Learned panel counsel appearing for the university, AICTE, and the
OJE.
OJE.
Mr. Misra.
Repel that contention, contending that if that contention is accepted, virtually that would jettison the statutory scheme evolved under the three legislations, namely AICTE Act, State Universities Act, and UGC Act. First one. The question requires a deeper examination is obvious. First one. However, the last date for admission, counseling and admission is fast approaching, and therefore we propose the following via media to expedite the process so that neither the institution nor the students nor the regulatory authorities are put to any prejudice. First one. Next paragraph. By way of interim arrangement, we propose that the fresh process.
What is that process? What is that process? Which has resulted in refusion? Space inspection process.
High inspection process.
Verification. The fresh statutory process for the purpose of according affiliation at the hands of the university shall be undertaken and accomplished with the participation of all stakeholders, including AICTE, within a period of 1 week. All right?
10 days. 10 days because in between.
No, 27.
No, because of state, so the Apex Court has fixed the date.
Then will be violating, then you will challenge this.
So again, that will be.
Odisha High Court has extended the date.
Absolutely correct.
May I pardon?
Come on.
Sorry?
A revised tentative schedule of activity for BTech examination will start for registration for second OJ will start on 24th, and it will end on this month, day after tomorrow, and it will ended on 28th July.
28.
So
28 can it be extended? Any idea? You are seeking your assistance.
Let them not finalize it.
Your Lordship order.
as per the 6 batches will be
Registration.
The students will register in my
Our proposal is you do it within 3 days.
Within 3 days you do.
my lord, in my counter page 4.
No, Mr. Misra, but not for you. Not 3 days counseling. The verification 3 days.
My lord.
Within 3 days.
And you come back with us, come back with any inputs, whether it can be extended, it can be kept open.
As I have taken instruction, it cannot be as per.
Can it be delayed then? Then the next question would be, can it be delayed for 2 days? You will start after 2 days instead of
28,
any precedence.
After 3 days, we will conclude so that within 3 days they will accomplish. Then after on the basis of that, they will.
You are saying 24th.
24th will start and 28th.
Start it on 26th.
27.
27 so 27 Sunday, no problem, or 20 Sunday? So it is an online thing.
It is online thing. So it will ended on 28th.
So 27th to 31st.
My lord.
Within 3-4 days, nothing will, heavens will not fall down. Nothing will happen.
Come back also.
That's possible. Within, shall be accomplished within 3 days.
My lord, my contention may be recorded.
Yes.
No.
Keeping open.
Sir, you are,
we will make up that.
This is regarding the Mr. Satpathy and Mr. Jena.
That's not.
We are yet to say anything regarding you.
Keeping apart.
Mr. Jena?
3 days may not be sufficient because the AICT will appoint an expert from outside because AICT does not have any experts of its own. AICT.
So Mr. Jena, who has inspected and given that thing? Same person can be, or you can have a new person from the nearby state.
From Bhubaneswar.
Bhubaneswar is online verification.
Online.
Now it has to be physical verification. So AICT has to.
So what fell from my lord is correct. That when they applied online, they were all teachers were there and physically no one is there.
There may be different because.
So you require an expert.
7 days.
7 days. You see,
Problem is another cut-off date is here.
Because one has
Supreme Court cut-off date and OJE cut-off date for counseling.
So
no, you require it from the outside state expert or inside state another university.
That AICT.
Because BPUT is only one university here in Odisha.
Yes.
So where from you get
AICT has to appoint some professor or lecturer IITians.
No, that they should do on one footing.
From IIT you can take. We'll direct now.
That is there.
IIT Bhubaneswar.
Yes.
Or NIT Rourkela.
Whichever they want.
Whichever they want to take
It's
that.
not a big process.
That should be left to the discussion with AICT.
Correct.
You have list of those people.
Yes.
You maintain a list of these people.
Only thing is the constant of time.
Choose one person from that list.
No other things, only constant of time. That is my only.
Within 3 days. Keeping the impugned orders at a bit, which will be examined if at all needed, come up in due course. First one. We have also noted we are fixing, we are aware that the period we are fixing is a bit short, but it is inevitable because of the timelines prescribed by the apex court for accomplishing the counseling process for admission to the courses in question. First off, we have also noted the submission of panel counsel appearing for the AICTE that the AICTE will have some difficulty in nominating its expert. First off, however, it is not that great difficulty since a list of experts is readily available with the AICTE. Apart, experts can be chosen from AIC, from IIT,
Institute of Technology,
Bhubaneswar, and the National Institute of Technology, Rourkela, or the like. First time. However, we are not expressing any imperative opinion in this regard. First time. But our concern that the process should be accomplished within 3 days has to be shown due deference. First time. Call this matter which date?
28 July.
3 days will be over when? So it will be intervening holidays.
26th. 3 days will be over. 26th.
So on 28th we will call this matter.
Yes, ma'am.
Call this matter.
Yes, matter 29th.
My registration will complete on 28th, madam.
The
In the
meanwhile,
Second round counseling. Mr. Be attentive, kindly. Mr. This is second round.
Second round.
The second round counseling at the hands of OJEE shall stand deferred
To start.
deferred to 29.
You are saying from which to which date?
24th will start and on 28th it will complete.
24th to 28th it was there. How many? 5 days. So if you start on 28th,
It will start on 24th, my lord.
so if instead if you start on 28th, how many days you require?
Thereafter, everything will changes, my lord, withdrawal of seats, exit from seat allocation, all these.
But all that will come to an end.
After registration, those students who are interested to withdraw, they will.
No. You are narrating the process, sir. We are not interested in to know the process even.
What is the repercussions?
What is the repercussion? Suppose you start on.
Everything according.
So can it be done from 28 to?
Everything will complete.
So how many days? From 28 if you start, how many days?
It will take 5 days.
28, 29, 30th, 31st, and 1st of August.
So accordingly, everything will be.
So you do it. Today by this interim order, you do it. So 1st of August. So that will not be that will be in consonance with Supreme Court order
Also.
That will done.
Yeah, it will be. Anyway,
so we can have it on 25th itself also.
25th.
Let us take a chance on 25th. You try to do it.
But after 2 days, we will start from 26th and accordingly 23rd.
No, this result we should have with us now. Before that. That's the reason we are asking you. We have taken a lot of time in this
because
matter.
it will help you only. Suppose, you must understand. Suppose we now direct after you complete. Can you do it? We have that power to direct you?
No,
Yes,
we have that power to
Yes,
direct.
that's what I'm telling Mr.
Yes,
Mishra. We have. So can you start recounseling?
No, man.
So it is in your interest. You must understand what has been deliberated.
But it would be according to the
meanwhile.
appeals court timing.
Yes, we have understood it. In the meanwhile, the second round counseling process at the hands of OJEE shall stand deferred to
Start on 20.
scheduled to be commenced on 24/7/2025 shall stand deferred to 28
July. That was. Sir, we will restrict on 25th.
28/7/2025. First time. Call this matter
On 25th.
for further consideration and compliance on 25/7
At 2 p.m.
at 2 p.m.
Yes. The authorities are requested to comply the process by the said date.
Yes.
May I request you also kindly upload the.
Yes.
So that I can.
Yes. A carbon copy of this order shall be made available to all the learned advocates.
Your Lordship, may I just pray just Miller, may I just pray to just add one line, provided your lordship will be pleased, Miller. If everything will be satisfied on the part of the BPUT or authority, Miller, they can pass, but they can also take independent decision with giving appeals.
For the authorities,
Miller.
shall be open for the
Yes,
authorities
yes,
after
Miller.
inspection to take the
Yes, Miller.
appropriate decision.
Yes,
in,
yes.
based on the finding in the report, irrespective of the pendency of this matter.
Yes. Miller.
Petitioner will deposit the required fees for inspection as per the
That will be suicidal. If they do not deposit,
Miller, 4 lakhs. We have deposited 4 lakhs something, Miller.
all statutory deposits and compliances
Compliances are to be done by the petitioner.
immediately.
Right now.
4 lakhs we have already deposited.
4 lakhs and 40 lakhs, you do not know. That you have to challenge another petition.
No, nothing comes free nowadays.
4 lakhs you have calculated as the student fee also.
Oblige, let's buy.
You advise your university also. University, AICT people and any other authority who is a participant, statutory participant. Okay. Just
document
do that.
The original copy may be granted.
Uploaded. It will be uploaded.
Oblige.
Send some.
Send somebody else to type. Both of you can start typing.
Sorry, we have taken a lot of time because it's a very important matter. In similar matters, we will not be taking so much time. Rest of the things we are ready.
The next matter also will not take time.
It will not take.
42.
Huh?
Identical 42.
42 also. Serial number 42.
And 42.
Yes, 42. Common order we can do. Okay.
Yes.
Item 14, my lord. Item 14, I prefer 1 week more time to get ready in this case.
14.
Yes, 1/4/14.
Who's for the other side?
State.
State is the other side. No difficulty. 14 is which one?
Which is that COVID.
76.
That
August.
COVID. Beg your pardon?
August, 20 August.
Yes, ma'am.
19th of August.
Oblige, my lord.
From 30, it will not recently taken up. And this metro was on board on Friday. Both husband and wife appear. My lord already recorded the statement and dispensed the personal appearance and directed to file a joint affidavit. The matter is in compromise. Wife respondent is staying with the.
They are present today.
Friday they were present. My lord has recorded the statement and dispensed the personal
So
appearance.
it will be taken up. After the personal appearance matters, it will be taken up.
Yes.
30 after the personal appearance matters. Sir, why you are standing there, sir? Please give him a seat, sir. Give him a seat.
It's an aged gentleman. Please give seat. Some youngster should give seat to aged people.
That much.
That's the culture.
Item 1.
Yes.
In the order paper 28/6/2022, passed by the new singers, under challenge, there is a limitation of 550 days.
Take notice. One thing. Take notice.
One thing, my lord, never glance to that judgment for me. It is at page 12. Under the Survey Settlement Act, 82, there is a provision for revision.
No, you are arguing on merits. So it has to be admitted.
Meantime, it has been settled by this.
Whatever, sir. The delay has to be controlled 565.
Let notice go on.
That order is also there. That whether the settlement authority can direct. But let it come for the admission, and here that stage has not come, and it is 565.
Issue notice both on limitation and merits, on main matter. Emergent notice. Any contempt or something is coming up, nothing. If that comes up, you can mention it. Yes.
Item 10. This is also a interest of appeal, wherein also there is a delay of 800 something.
So Sahoo, you file objection to the IA?
I've already filed the objection, yes.
800 days.
What 880 days,
886.
excluding the limitation period, there is 880 days.
But 15/9/21 is peak of COVID. It continued till 3rd of April, end of April 22.
End of April 22.
So
if that is excluded,
so at least 8 months have to be excluded.
This is May 20, not April. It is May.
It's May 22. 5 plus
This is May 20.
8 months. 240 days have to be deducted.
Here is the case file. This is the order challenged by the state appellant.
no, that's all right. But because of the apex court decision, that period stands excluded.
This is already decided, and similar case of a rate appeal has been filed before this honorable court
On merits.
On merits since 22.
Let us condone the delay then.
Since 22. This is the judgment, common judgment.
If you are relying on the judgment, you serve on him.
No,
so that he can respect
that is the averments of the IML.
They only have said
Yes,
that.
yes, already I heard. In the IML. Read paragraph 4 of the IML.
No, which order you are referring, I cannot get you actually, what you are saying. So if you are relying on some judgment of this coordinate bench, kindly serve that on them, so that they will be in a position to respond. That is in your favor.
My lord, I am submitting, my lord, in the IA, my lord, delay condition limitation between IA 12221.
So you are opposing the condonation of delay?
Yes, I have filed the objection.
Merit saying something else.
In the IA, I have filed the objection. Now, question of delay.
No, merits what you have to say, because we have received now.
Because
of Sahoo, can you please listen, sir?
My lord, only my lord.
Supreme Court has sent back around 1,000 of writ appeals which were dismissed on ground of delay back to High Court for consideration on merits.
Yes.
So that is how we were asking you that if we condone the delay, what is the case on merits? So then you started saying it is covered by some decision. So that is how. So if you are aware of any decision of coordinate bench or Supreme Court which covers your matter, then apart from delay, we have to consider merits also.
Odisha so we can condone delay. We can condone delay subject to they making some payment to you. Let them make some payment.
Once my lord, similar case, it's a common judgment.
Sir, you are reiterating, sir. Similar case, common judgment, which is that you rely
already before this one, sir, pending adjudication and there is a stay.
That will number.
My lord, that is the question. Well, in the IA, my lord, which is in the limitation notice, paragraph 4, he has stated WA number of 557 of 2022.
That itself is rejected.
Yes. And that case, the stay has been.
That is the adjudication on merits or delay.
Merits, my lord.
Where is that decision? Show that, sir. How many times I have to tell you? Please show that judgment which you are relying on.
That is, my lord.
Sir, kindly show the entire judgment, not the reference. Said by Supreme.
That is the Suramamanjari Sachar.
So already this order, you are relying on WA 1097 of 2022.
557, similar case. My stand is my.
No, sir, you get prepared in your brief.
No, my stand, my
letters of respect, you are not following whatever is being told to you. This is 1097.
This is my IA.
You are relying on WA 1097 of 2022. I'm not relaying, man.
Normal.
Then
No, you want to submit on the ground of limitations. Apart from that COVID period, so other part of the delay is similarly matter which is subjudice before this honorable court in writ appeal. Because it is subjudice for
so
that.
then what we are telling him, he accedes to that. About 1,000 matters have been
remanded court to this
to the listed also. So if that is your only sole submission, then you take time to prepare for on this.
Man, I will submit, my lord. That's
We are not following actually. Have you seen what has happened to this writ appeal? Already this
That order is set aside.
coordinate bench relying on Surma Manjari,
That has been already shown.
dismissing appeals on ground of delay, going to Supreme Court. Supreme Court now remanding back, condoning about maximum is about 500 days or 340 days delay. In your case, if you deduct about that's 270 days, when it comes to around same 500 days delay.
Therefore, we are suggesting we'll condone delay. We'll direct them to make some payment to you. Next date, you can argue the matter on merits itself.
Definitely.
Can we do that?
Yes.
State appeal is filed after a booking a long delay of 800 and odd days. First off, an application supported by the affidavit accompanies the appeal memo seeking its condonation. First off, objections are also filed to the subject application by the respondent. Employee.
Teachers. This is
Not apparent.
contractual teachers.
Respondent teachers. First off, learned counsel appearing for the respondents vehemently opposes the delay, contending that explanation is not plausible and delay is too long to be condoned. First off, he also drew our attention to a coordinate bench order in writ appeal number 557 of 22.
1087.
108, not 1087, 1097. 1097. Writ appeal number 1097.
It is not sure actually this time. That itself is not sure.
I'm not sure.
ଆପଣ କୋଉଥିରେ ସେ delay କଣ୍ଡୋନ ହେଇଥିଲା ହେଇକି dismiss ହେଇଛି କୋଉଟା ସାଇଟ୍ କରୁଛନ୍ତି?
I am not citing when I am not relying.
You are not relying upon
Yes, yes.
Good.
I am only.
Next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered opinion that delay in matters like this should be viewed a bit leniently, state being the appellant. First off, we have also noted apex court decision in
Sevraj Singh.
no, not that. Sudhanshu, what is that? Sudhanshu
Jena.
Sudhanshu.
The number is
Jena. That's fine. So, where is long delay?
146.
Yes, that's fine. So, then take that. Wherein long delay having been condoned, matter has been remitted to this court for consideration of fresh on merits. First off, condonation of delay would not add merits to the appeal to the disadvantage of the other side. First off. On the other hand, appeal will be heard on its intrinsic merits with no prejudice to anyone. First off. Much older matters than these are stacked in the court cupboards. First off. Next one. In the above circumstances, application having been favored, delay is condoned. Subject to the condition that the state shall pay rupees 2,500 to the... How many respondents? How many respondents, brother?
Only I has been served. My land brother can say that.
How many respondents? One respondent.
By a bunch of cases, it has been disposed of, but one.
One to the respondent within 2 weeks. Filling which?
No, there are 8 respondents.
Huh? To each of the respondents. Anyway, to each of the private respondents within 2 weeks. Within 2 weeks.
You have to find that out of the 816 is what has been the delay from
Later concluded more than 8. That was it. All the matter.
Another rate appeal also there. With
Similar matter.
Yes.
Call along with.
Yes.
Call this matter
That is all
with
on the list, madam.
it's there already.
And you take to that is WS 628. 500 to each. How much you will?
2 weeks we have given, 3 weeks.
Use. Because 2,000.
2,500 each. Then they will wake up. Otherwise, they will not wake up only. They sleep.
And let it be.
And they are
looking
looking
for
after 8860. And another WA. What? Sub item, same order? Yes, sub item.
So we mentioned both the writ applications where it has been demanded. Another one is enough. Sudhanshu Jaina.
Sudhanshu Jaina. Yeah.
Item 11?
Item 11, here my lord, 8 and in other sub-item, this is 7%. Total 15%.
15%.
Mr. Sahoo, 2,000 each.
2,000.
2,000.
You said lordship, please.
2,000.
No, you said only 2,500. We are paying it now. I am not you say that only one. No, my lord, there is first one is 8 candidates and second one 7 is to 15.
Then if there are 8 persons,
yes,
take 1,000 rupees each. 1,000 rupees, because it will be reflected on them. 1,000 rupees each. Totally 8,000 or 8,000 rupees it will be.
Out of 15,000, sir.
15, other 7. Yes.
May I please, Lord? Item 11, 63 days preferring the intra-court appeal. Since my learned senior is appearing in this case, my Lord, your Lordship consider the delay, my Lord, keep it on some other date for hearing.
Yes, sir.
Soft copy?
Already, sir.
Can you condone the delay?
63 days.
I will condone the delay. In your matters also.
Technically, I don't object to that. But my entire anxiety would be, Lordship may keep the matter for hearing and merits.
Yes. Let us see. Let one stage by stage.
But I'm interested in that.
With a short delay of 64 days. 63 days. First one. The same case. Hello.
56 days.
Delay short. 56.
56 days.
56. Delay short explanation is plausible. And there are arguable points to be made. And first review of that application if delay is controlled. Yes.
Fix up a date for final. That your Lordship would kindly. Mr. Mansi, agree for a date?
Any urgency?
But in fact, it's a question of only pay, scale of pay, discrimination viewpoint. That's all a very short point. It will take 5 minutes for your Lordship to decide.
On 13.8 we can have.
That will do.
Okay.
Grateful.
13.
Item 12, Lordship may kindly have a glance to order dated 7/7/2025.
Where we have allowed.
No, 7/7/2020, Lordship directed the registry to put all the workers establishment cases before Lordship with a batch. That registry has endeavored, but has mixed up the job contract matters also in the list.
No, job contract is we have already rendered that judgment. For
Yes,
job contract,
job
contracts we have already entered, but findings.
So have you made that list of job contract?
List of
It is on the converse. If you have distinguished between job contract and so let it come tomorrow. You make that list. We have no difficulty.
Number
See,
one.
this is now. My humble understanding is that it could have been disposed of by the Supreme Court after reading Sudhanshu Jaina, Sudhanshu Jaina, but it has been remanded back. We have been
No, in job contractor, you have to count because of rule 18(3).
Yes.
Full relief has to be given to them.
That is
That is 18(6).
18(6).
Job contract
We have already allowed the appeal.
So identify those. You take time, but do something. This can't kept on hanging like this and kept with us. Tomorrow, so you at least make an effort.
No. Day after, grant us 10 days time.
Not 10 days. 10 days. You see, the problem is that they have condoned the delay subject to payment.
1,50,000 they have to make payment to the employees. Where have you made the
delay
payment?
has been caused, delay has been belated stage
Whatever it may be, sir, they have
the language. Not in all cases, where there has been belated case, the state has appealed, filed it appeal.
Correct.
My lord, we will consider, we have to pay that. Because your lordship
Mr. Ponda, because we have already completed your job as far as 18.6 is concerned.
Yes.
So wherever 18.6 is applicable,
We will segregate that. We will segregate them.
So now at least, and this is our effort also in the sense that now Supreme Court is taking up those review also.
Yes.
Again, those review matters will be sent back to us.
It happens. For that purpose only review. Review is for that purpose.
That purpose only.
As my brother said, they will not decide that.
That last paragraph, Sudhanshu Jana,
Yes.
that review can be filed by the appellate
Within 4 weeks.
4 weeks. They have filed now review.
Number one, why payment is not made? When highest court country of the highest court says, and still payment is not paid, why we should entertain your appeal?
It is in process, Lord, it will be paid.
No, time is fixed by the Supreme Court.
Fixed.
For making payment, 2 months' time is granted to you. Then why we should entertain the appeal of the state, which does not respect the Supreme Court of the
And
country?
you are having the cake and eating it through us. And we are saddled with the criticism.
In job contract matters,
Mr. Ponda, we are also being pointed out that we are not disposing of cases, even remanded by the Supreme Court.
In job contract case, we were not informed that you have not made the payment.
We do not know actually.
And nobody mentioned so much money is paid. Nothing is mentioned in that.
that we have to segregate.
One way, Mr. Panda, is that you deposit in the court in the interest-bearing account. That will save you. Because I think you will find it difficult to locate the persons also.
Yes.
You deposit at least in the registry of this court.
Interest-bearing account so that we can record that you have complied with Supreme Court order.
Lordship may grant us 10 days time, my lord, for that. 10 days.
So,
Hearing, my lord.
Mr. Malik, just a second. Let it not go out of the list. Let it not go out of the list.
No, Lordship,
they are
Out of the court also.
Not out of the court. Like we will be facing this difficulty. So so let it be. They are recurring. Let it continue in the list. We
will say that we have heard this matter because it cannot go on like this. We have partly heard these matters. First off, there are 2 classes of cases.
Everything is taken care of.
Which need segregation. First off, there is another aspect to the matter. Namely, the apex court in Sudhanshu Jena, so and so.
SLP number is written in the.
All right, we have that.
They will find order number 2.
Having condoned delay, has saddled the state with a liability of rupees 1,50,000 payable to each of the employees.
Wherever
delay was occasioned. Wherever writ appeal was filed after booking delay.
Belated appeal.
Yes. First up. This order of the apex court has not yet been complied with, though the stipulated period for such compliance has expired. First up. On this ground alone, these appeals can be negatived because not complying with the order of the apex court is a very serious thing. First up. Be that as it may. Next paragraph. Learned State Counsel Mr. Panda, appearing for the appellants, submits that it is difficult to identify each of the private respondents and hand the money as directed by the apex court, and therefore the state be permitted to deposit entire money in the registry of this court itself, so that the said amount can be dispersed by to the employee concerned by identifying him.
After notice is being issued also.
But notice is issued.
So that instruction, how much money you will deposit and all that, you have to work on that also.
Yes.
You have just left it like that.
No.
Then at least today could have concluded the entire proceeding. Today why we are sitting? Because the matter is decided by us.
Mr. Panda also submits that the entire money will be deposited in the registry. Within 1 week.
10 days.
10 days. Within an outer limit of 10 days. Full stop. Since a delay is brooked in making the payment to the employees in disregard of the apex court decision, comma, we direct the state to pay another sum of rupees 5,000 to each of the employees in addition to rupees 1,50,000, comma, wherever belated writ appeals were filed. 5,000 extra you have to make now. 1,55,000 you will get. Call this matter for further hearing before this bench on 2nd of August. Saturday, Sunday, 3rd, 4th. 4th of August. 4th of August. Both for segregation and for making payment as indicated above.
Only work charge employee cases will be listed on.
No. All the cases. Sir, you have to.
Whichever matters are posted.
Complicating things. Suppose the matter is taken up. If you tell us it is work charge, is it that we will not be able to
we'll release that.
We'll release that.
That's all. Therefore, let all matters be posted. We can take individual cases and say ordered.
My lord, my first case, that is 2,200 by 24. That is my case, that is work charge case.
Work charge.
Yes.
So, Mr. Bose, yes, we also request the bar because you must understand the enormity of the task.
Yes, ma'am.
As a lawyers also, they have some difficulty.
Yes.
So if you are sure that work charge, you give that list, they will again verify.
Yes.
So if you agree that this is work charge,
yes, ma'am,
that will go out or
yes,
will postpone the hearing there. If it is work charge, they have to make payment.
Do you have to make the payment?
But because of that observation of the Supreme Court, they want to argue it.
No, my lord. Sorry.
18.3.
18.3. So
full service has to be counted.
That has to be.
Even apex court has said it is Sudhanshu only.
Sudhanshu, it is para 15, it has been clarified. Consideration of But now we are in the job contract. So if at all this will be segregated in another way.
About 18.6. 18.3, they made a passing reference.
But that was not the subject matter also.
It was discussed, but it was kept open for your lordship to consider.
But we have seen that there is nothing in your appeal.
Your lordship has seen, but it has to be submitted.
Text of the rule itself covers everything.
While dealing with job contract, your lordship has
you get all those job contract cases, the cases on that day.
Once it will be segregated, it will be easier to.
But
all right, no problem.
Some cases, the honorable single judge also directed that qualifying service should be taken up for the pension. In some cases.
But Mr. Panda, as my brother said, where is the difficulty? If you point out it is work charge, immediately we will take up it and keep it apart. Then next matter we will take. This matter is here. Suppose we cannot keep this matters also pending like that.
And we will accordingly appraise your order.
Anyway, they need not be segregated. No need.
So that has to be in the presence of both the sides. Or maybe somebody is not appearing.
Office will not be able to know.
Office will not
be able to know which is which matter. Right. Therefore, let matters come before us. We will segregate them on our own because parties are here. But we are of the considered view. There you have no case.
Now, Mr. Manthi has thrown a spanner that even in Varcha there are judgments to that it is only for counting for
qualifying service.
So for that they have to challenge. You are saying
yes.
Unless they challenge that, that is binding.
There are such judgment.
We have also filed writ appeal also against that, but
the problem is why it was carried to Supreme Court. The Supreme Court didn't realize also. Yes.
No, they have not told about that at all. Yes. All right.
One, but item 36, writ appeal. Had earlier. Your lordship told urgently, only awaiting your lordship's judgment. Your lordship has already delivered judgment in the similar case.
That judges matter.
Yes, my judgment.
It requires consideration. We went through.
One part. Can it take up my lord next week?
Next week not possible. Then the third week of August.
Short date, my lord.
Yes, short.
Right. 21.
All other matters to distribute them.
Item 15 is a covered matter. Your lordship.
Wherever, sir, you are wanting a long adjournment, kindly suggest that.
Covered matter.
Covered matter.
Which is that matter?
Your lordships have decided the leading case, dismissed the writ appeal filed by the government, and our matters were disposed of in terms of their judgment. Your Lordship already covered. Covered. I have already given.
You
first
copy
hour.
to one thing.
I have given first hour.
In that, that there is a fourth employee and
One of the employees.
One of the employees. And delay is there.
Covered by this. So then please give all the copies. They will sign that out.
Delay. There is a delay. Some delay. So
How much delay?
Delay. Lordship.
223 days in the first case, and second case is 238. Your Lordship also.
So condoned 185. It has been condoned. 238 it will be condoned.
Your Lordship condoned and passed the order.
223 first matter. Second matter is 240.
Can you carry out the necessary changes in the pencil in this order?
Same order will print that.
My Lord,
And both of you sign.
My Lord.
Item 18, my lord, is a condonation of a delay.
Item 21, my
It
lord.
is going out of list. Just give us some time. It will be
Wrongly it has been listed. Come tomorrow, face admission. Item 35, notice has not been issued, but is wrongly listed in the after notice.
That you show to him because he doesn't realize. Registry doesn't realize. But
Only
showing
bill
that
has
there
been
is no order.
Yes.
Showing that there is no order. They will write in the mention memo.
Yes.
Item 21, my lord, I pray tomorrow. Tomorrow. But orders is possible. Orders. You have to ensure that judges also leave. Tomorrow, my lord, there is a review petition and